This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the private limitations of action provision in almost every first-party insurance contract, fire insurance contracts, homeowners contracts, and why the Ninth Circuit found that COVID-generated rule tolling statutes of limitations does not apply to a private limitation of action provision. William Scollard sued State Farm after it denied his insurance claim, alleging that two antique items worth $126,000 were stolen from his vehicle. The district court granted summary judgment to State Farm, finding that Scollard's suit was time-barred under the homeowners policy's 1-year limitation period. Scollard appealed. In William Scollard v. State Farm General Insurance Company, the United States Court of Appeals for the Ninth Circuit on November 1, 2024, dealt with Scollard's argument that Emergency Rule 9, enacted by the California Judicial Council in response to COVID-19, tolled the policy limitations provision. The Ninth Circuit noted that Rule 9 only tolls statutes of limitations and repose. Scollard argued unsuccessfully that because the limitation provision in the policy is mandated by California Insurance Code Section 2071, the standard fire policy, it should be considered a statute of limitations and thus be tolled by Rule 9. California law also at times distinguishes statutes of limitations enacted by legislatures from contractual limitations period, which are bargained for terms between the parties. Limitations periods in insurance policies are not statutes. They're not statutes of limitation. They are contractual limitations on the insurer's liability. In certain circumstances and for some purposes, policy terms mandated by Insurance Code 2071 are properly treated as a statute of limitation, but Insurance Code Section 2071's mandated provisions provide the same result and are treated identically to statutes of limitations, but they are not statutes of limitation. The Ninth Circuit concluded that because Rule 9 arises from the much broader context of COVID-19 and applies widely to all statutes of limitation, excluding contractual limitations periods contained in homeowners policies from the rule's scope, does not defeat the entire purpose of the rule. Neither does the language of Rule 9 support a reading it as applying to contractual limitation periods such as that in the State Farm policy. The drafters of Rule 9 did not include or contract, the words, quote, or contract, close quote, in Rule 9. It left it out. Absent any specific indication otherwise, there is no basis in California law to infer that the Judicial Council intended Rule 9 to toll contractual limitation periods. The Ninth Circuit concluded that Rule 9 does not apply to Scollard's claims because Rule 9 only tolls statutes of limitation, not limitation provisions contained in contracts like Scollard's policy with State Farm. In my opinion, for a reason unknown to me, people and their lawyers tend to forget that an insurance policy is just a contract. Every standard fire policy and every homeowner's policy contains a private limitation of action provision, usually 1 or 2 years after the loss-causing event, unless waived or extended. In this case, Scollard filed his suit against State Farm after expiration of the private limitation of action. Although California Judicial Council enacted Rule 9 to extend statutes of limitations because of the lockdowns resulting from the pandemic, it did not even mention private limitations of action provisions, and Scollard's suit was therefore time barred. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 4,900 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, you can gain access to all the videos. Please tell your friends and colleagues about this video and the blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.